It's a pleasure to have you here, face to face. It's important to meet face to face, such as was the case for Ms. Antarena this morning. It's important to be in contact with the audience, and we appreciate it a lot. Mr. Salt is a very important person as regards this topic. I know that you don't have much time, so we thank you so much for being here. And we also have an important panel. Gonzalo has COVID, so he couldn't be here. Gonzalo Garcia Belenguer, he's Spanish. He worked in 60 in the OAS for a long time. We organized the CyberSec School in 2016 in OAS, but he has COVID and he's not feeling very well. But we do have Carrie-Anne Barrett, who is the 60 OAS coordinator, who is based in Washington, and our friend Vanessa Fusco, who is in Minas Gerais in Brazil. And Maritza, that is our friend from Peru. Thank you, Marisa.
¿Me escucha? Porque ella tiene que escuchar el canal de español en YouTube. Ok, Maritza, ¿me escuchas bien? Me parece que no me escucha nadie. ¿No?
Marisa, can you hear me?
Sí, I can't hear you, although just that the English translation is delayed.
Thank you. Carrie-Anne, for you, if you want to follow the
Carrie-Anne?
The YouTube channel, and there's a slight delay, but you can handle that. I'm sure about that, and I'm sure that Vanessa and Maritza and Marcos are bilingual, so you don't need to. No necesitamos. Okay, Maritza, todo tuyo, y gracias por estar todos aquí con nosotros.
Muchas gracias, Olga.
Thank you, Olga. It's a pleasure to be here with you. Thanks for the invitation. It's really a pleasure to be here in this important panel with a very interesting topic that we are going to address. So I'm going to introduce our panel, Mr. Marcos Solt, Carrie-Anne Barrett, and Vanessa Fusco, who are here with us today to talk about this important topic, that is international regulations in cybersecurity and cybercrime. Cybercrime is a huge, persistent problem that has been relevant in the last years. There have been different attacks that are focused on different fields, and here we need to highlight the international law in cyberspace. As the name of the panel indicates, we're going to be talking about international regulations in cybersecurity and cybercrime. We have coordinated this panel, and I am very pleased to be moderating it. And first of all, we are going to listen to Mr. Marcos Solt, who is going to talk about the new challenges for international cooperation as regards cybercrime. Thank you. Marcos, the floor is yours. Can you hear me? Thank you. It's a pleasure to be here with you today. And as I was saying, Olga, even if sometimes you need to make an effort to be here, it's so important to have these kind of panels and these kind of talks. We need to contribute to this. And I want to congratulate you on organizing these kind of schools. It's a pleasure, Carrie and Vanessa. I have had some panels with Vanessa already. We don't have much time, so my idea is to try to give you an overview of the problems that I see, or that I identify, like old challenges in international cooperation as regards cybercrime, and the new challenges. The old challenges, maybe you all know about it, but those are challenges that we are still facing. And the new challenges have to do with things that are being added as regards international cooperation. So I'm going to give you some ideas. I'm not going to be able to talk about all the problems in 15 minutes, but I'm going to give you just a couple of ideas. I'm not going to talk about cybersecurity. I'm going to talk about cybercrime. I know that these topics are related, but it's not the same to talk about cybercrime and cybersecurity. Actually, an active cybersecurity policy is going to influence in having not so many cybercrimes, but these are different legal frameworks, and there are some specific details that we need to talk about. So think about this so that we can have a discussion. But one of the important things that we are discussing as regards international cooperation today is that if we are going to continue analyzing cybercrime as a separate issue from cybersecurity, at the international level, when we talk about the Budapest Convention and the UN proposal, you are going to notice that the big difference between both is that one has preemptive policies connected to cybersecurity, and the other one has to do when a cybercrime has already taken place. So, is this difference so important for the future of Internet? Yes. I'm going to mention some of the reasons now, but we are talking about things that, although have to do with a legal framework, there are some economic and political consequences. If we allow governments to have a previous control, we're going to have a more controlled internet. If the government is going to be acting after a cybercrime, we're going to be talking about specific crimes, and the government is not going to be doing some excessive control on internet. Those are two different ideas. So we need to analyze the problem of cybersecurity and cybercrime. When we talk about international cooperation, let's talk about the old challenges. We are talking, from my point of view, of a paradigm shift as regards the legal framework in international cooperation. Those who work with international law and changed a lot with the digital era, since it became something important, and the evidence that I can use, for example, the digital evidence that I can use, the same took place in international cooperation. And also because we are not talking only about cybercrime, but also digital proof has been included in any kind of crimes. There are digital proof or evidence in digital evidence in all kinds of cases. And this digital evidence that was in one country, now it is in the cloud. We don't know where it is. Actually, of course, we know that the cloud is kind of a fiction. It's there somewhere. As an old professor used to say, it's not that we are losing the place of that, but we don't know where it is, but we know that it's there somewhere. So this gets us to have the digital evidence as a transnational evidence. So we do have it in electronic devices, but also in hostings that may be outside our jurisdiction, but pose a challenge for international cooperation. We have been talking about this in previous schools, and those are like old challenges that have to do with data access. And for example, if I am in a certain country and I need information that is in another country, which are the ways of having access to that information? Well, we have the possibility of having access with the device that I'm going to be registering. For example, if I have Adrian's computer, I am doing an investigation and I see that he has information in Dropbox or Facebook, and what I do is I do a registry extension and I get the information there. I can get the information without the device with some mechanisms. For example, somebody tells me that Adrian has all the information in the cloud and I have his user and password. So I do it from a computer and I have access there. And then everything that has to do with informal cooperation or asymmetric cooperation, that has to do with cooperation from Microsoft, Facebook, Google. We are talking about the US, not European countries, because they are not going to be giving us that information. And the same case would be in Argentina, because the Argentina legislation wouldn't allow that. These are problems that we have been having for more than a decade, and that's we need to try to solve, because this creates a paradigm shift. Even in multilateral or bilateral treaties, you're not going to be seeing chapters about digital evidence. And since there are no mentionings of the digital evidence, this is not efficient. So we are like talking about the difference between the technological common sense and the legal sense. For the technological common sense, there are no problems in order to obtain those evidence, but from the legal point of view, we still based on national sovereignty. So we are trying to apply the national sovereignty principles to internet, which has no borders. So that creates lots of problems, and there are many informal mechanisms of cooperation. Any kind of informal cooperation, for example, Interpol that will send you some data through a police officer, an attorney in Brazil would send information to a friend, an attorney friend in Argentina. So what is the problem here? The possibility of making those processes null and void. This is something that has been going on for a while. And now we do have a new problem that I think is important, that has to do with the fact that when technology improves for committing crimes and anything that has to do with encryption, the possibility of searching the internet in a hidden way, the possibility of having AI creating fake profiles, and some kind of problems for those who have to investigate crimes. And this has created new tools. And if I have, for example, the governments that cannot investigate, for example, I have information that Adrian is doing some money laundering, for example. Sorry, Adrian. And now we will have to, I may be an accomplice. Let's imagine that I have that information and I have access to Adrian's computer, but he has part of the information in the cloud and is encrypted. Or maybe I get crypto assets. Then that is another level of difficulty. Let's imagine that I have everything. What can I do with that? All those problems that are part of this new problematic have made governments to look for new investigation tools. If we take some basic information, we have the undercover digital agent, the Trojan programs used by governments, the big data now seeing techniques in a more comprehensive way than in the past. So we do have some investigation tools that we can use. So if I ask somebody to be an undercover agent in order to investigate a a group that is selling drugs on internet, it's going to be very difficult to tell the undercover agent that he is working for Argentina only. And if I decide to use a Trojan program that is enabled in the US, in Germany, in Italy, Portugal, do you think that the Trojan is not going to be coming to Argentina because we're going to be asking it for a passport? Of course not. So this is creating a lot of new problems. And what I am discussing now in Europe has to do with the EncroChat case. I don't know if I have time, Olga. In that case, probably it is the most efficient investigation in the last 50 years. It has to do with using a Trojan with a French judge that was able to get a lot of communication from all over Europe, and they were able to get one of the organized crime organizations. We are talking about really bad people, and a lot of them. We are talking about drug trafficking, murder, and a lot of crimes that are involved there. Of course, evidence was found in many countries, and nowadays those evidences are being introduced in court, and there are a lot of problems, of course. A judge in Berlin said that the evidence was null because he said that he wouldn't accept it in Germany. So when they realized that it was going to be a very complex issue, they said that they were not going to act against a French judge decision. So all the data that they found about German citizens are kind of not involved. So when you talk about the EncroChat case, they acknowledge that it's very difficult to continue with that, but there's an international need to regulate the cooperation convention. So let's talk about the situation, the global situation. The most important step probably has to do with the second additional protocol for the Budapest Convention this year. That is important for Argentina because Argentina is a member country, but also for the region, because if we think about the region, with Brazil now being part of this and Uruguay as well, and Mexico that is all the time trying to continue working on this. If we think about what happened with the second additional protocol, everything that I have mentioned was part of the agenda, and everything was analyzed in the meetings that were held. And I was lucky enough because I learned a lot by being part of one of the groups. And when we started talking about personal data and the difference between the US and the European countries, the opinion of the different countries, which was a result, we were able to solve a lot of things. For example, asymmetric cooperation, the fact that an attorney in Argentina can ask a provider in Chile or in Germany, that was solved through a mechanism that would ensure data protection. But as regards the new challenges, in the drafting, there was included something about undercover internet operations for transnational evidence. And this kind of steps were not agreed upon. And we have already drafted the articles. So there were 66 countries included. Argentina was part of that. And those countries, many countries said no. So from the point of view of the interpretation of the rules, I can say, well, this is something that is going on. But in the text that was published in May, there's a part that says that there was no agreement upon countries because countries were not able to agree that an agent in a country could get information from another country. So when we see that those challenges were not solved, the registry extension that I was talking about, which seems to be something very simple. If I am working on a case here in Argentina and I have a connection through the cloud to another country, a regulation that was mentioned that offers some different provisions, and it was not agreed upon and it was left out. And this is something that in Argentina and in many countries in the region takes place every day. But for example, if you go into my Facebook or my Dropbox account, you're not going to have a problem unless, or Adrian's account, unless he is a CIA agent and we don't know about it. But imagine that you do it with an FBI agent. Do you think that the US is going to take it as something that is okay? If you do that and you don't have the authorization of the American authorities, that is going to be a crime. It's going to be legitimate access, illegal access. So the old and new challenges require a kind of articulation in order to modify the international cooperation conventions. And we need to debate that cooperation. The second protocol was an improvement. I believe that new challenges were not solved there. And I believe that the UN Convention won't solve it either, because if there was no agreement between among the 66 member countries, more difficult it's going to be when you have to include the US, the European Union, Russia, and China in the same table discussing this. I don't imagine China saying that if an undercover US agent is investigating, they can do it, or the other way around. That is not going to happen. So these kind of problems are going to continue. And we need to pay attention to this. There are, for example, some FBI agents that were prosecuted in Russia for this. So we need to pay attention to this, and we need to try to continue working and to promote discussion among countries as regards this, and to try to reach agreements. I believe that I stick to the time. It was very interesting, and it seems to be such a complex issue. I imagine that the drug dealer lawyers have a lot of resources and a lot of tools. For example, Adrian's lawyers, attorneys. Nowadays, what I have been seeing in Argentina, Colombia, Chile, there are still not so much activity from defense attorneys because this is very new. But there's going to be some change as regards this. And we need to take into account that informal international cooperation has been moving forward in all the crimes that have to do with minors. So I'm sure that everything that is being allowed in those cases won't be allowed in other cases. So if I tell you that I'm going to have the private sector companies doing some searches on social media to see which Argentinian citizens may be doing some fraud, fiscal fraud. And if I find something, I inform the state. Nobody's going to accept that. But if I say that I'm going to do it for sexual abuse, probably they are going to accept it. So the tools that were developed for child abuse, if I change something in the code, in the peer-to-peer networks that I use, I can be use it for somebody that is, for example, doing something different. Marisa is telling us that we have no more time, so I'm sorry, Marisa. It's okay, actually, but Marcos gives great presentations. He talks about new challenges on international cooperation and crime, and I was thinking about the efficiency of the evidence and the incidences in order to have the necessary means for an adequate investigation. By listening to Marcos, I'm sure that there are going to be a lot of questions on the audience, but now we're going to continue with the next presentation. I'm going to switch to English. Olga, so I can introduce our next speaker.
Yes. Right now we are going to present to Karian Barrett. She's going to talk about the regional organization role in the open and working group from the OAS perspective, and some reflections from our judicial committee about international law applicability. As you know, she is the cybersecurity policy specialist from the cited OAS. Welcome, Carrie. Thank you very much, and please go ahead with your presentation.
Thank you, Marissa, and thank you to SSIG for having me here. Thank you, Olga. We have such a great relationship over the years, and it's really a privilege to speak at this session again. I want to pick up where Marcos left off and to give a macro view of regional bodies and how we work in international law and how we support some of the efforts that Marcos has spoken about. At the OAS, I think it's important to tell those who are listening that the cybersecurity program has been around from as far back as 2014. And one of the goals is to bridge the gap between our member states' technical experts and their policymakers, as well as other stakeholders, to ensure that they actually speak the same language on some of the issues and see threats through the same lens as much as possible. We believe that countries must be prepared to adapt quickly to the dynamic environment and make decisions quickly based on a constantly changing threat landscape. Marcos gave some really good examples of cases and how quickly things change and the need for digital tools. And we believe that our member states must understand these concepts in order to manage the risk and understand the impact and the likelihood of this impacting their citizens, organizations, and national critical infrastructure. Therefore, to improve cybersecurity in the region, one of the things that we consider that it's important to have a comprehensive and sustainable cybersecurity policy. In 2004, OAS member states did a regional cybersecurity policy that was implemented across the board with the intent to have a common understanding or goal towards working towards regional cyber resilience. Now, if I take it up to the macro level to regional organizations, not just the OAS, but if you think of ECOWAS, if you think of OECS and other bodies such as the OAS, we play a complementary role to some of the activities that Marcos speak to. We as regional organizations are platforms for exchange to achieve a broader global agenda while contributing to the applicability, implementation, and commitment of the UN recommended norms in their respective regions. Due to the economic and social and security proximity between regional organizations and their member states, it is important to recognize that as regional bodies, we actually have an intimate understanding of the challenges and the mitigating measures needed to respond to each of our member states' specific context. Therefore, as regional bodies, we can leverage on the connections we have and the commitment we have to support the UN efforts more broadly. Marcos spoke about the Council of Europe and the protocols related to the Budapest Convention. And if you take it to the other side, which is the UN convention that is being discussed at the ad hoc committee, or if you talk about the UN processes in the open-ended working group around ICT and the need to develop norms related to that, regional bodies such as the OAS can actually help with these discussions and why and how it benefits the region. One is to consider applicability. Building on the need for trust and establish relationships for UN norms to actually be used at the national level. Regional organizations can play a significant role to build that trust. We can contextualize the norms. We can assist our member states in adapting them to their national realities. And we can also support them in implementing concrete actions to take into account what the global norms want to achieve. Another aspect is accountability. As regional bodies, we have a crucial role in actually supporting our member states in global governance, considering that global norms are intended to be promoted at the international and regional level. We as regional bodies can add accountability for our member states and help them to implement it. As an example, at the General Assembly last year, OAS member states agreed that there was a need to implement the norms that was agreed to at the UN level. More specifically, at the 50th session in 2020, member states actually had a resolution that there was a need to support member states in the implementation of the 11 voluntary non-binding norms of responsible state behavior endorsed in the UN General Assembly resolution, and the need to ensure that there were capacity building measures to support member states in doing that. Another thing that we have to consider in terms of how regional bodies play into this whole discussion of international law and applicability is that inclusivity. As the OAS, we do have a broad platform to be able to carry multi-stakeholders together to discuss these issues. So we can reach out to civil society, government bodies, private sectors. So in terms of being a body, we are a driving force for inclusivity and can provide a complementary platform to ensure that there is a more representative perspective of stakeholders at these discussions. The reality is that because cyber landscape is highly interdependent, no state can succeed in and of itself. So with all the measures that we could put in place for building capacities to investigate cybercrimes, or we may put measures in place to build cybersecurity capacity, because it is so intertwined, there's a need to ensure that organizations such as the OAS, we can actually be a key player in advancing development and adherence and implementation of established norms and decisions. I want to give the audience just a few quick examples as well as to how we build capacities to support the efforts that have been spoken about before. As an example, since 2017, the OAS has been doing a course that was done in collaboration with the government of the Netherlands and with the Cyber Law International Group that was called the Hague Process. That course is being implemented today as we speak in Dominican Republic. And a part of the focus of that is to ensure that member states understand what is the international landscape they work within and the applicability of international law to cyberspace. Another thing that we've been doing is several cyber diplomacy courses. Those courses focus on familiarizing our participants on the UN processes with particular reference to the United Nations First Committee. We provide participants with an overview of the normative framework for responsible state behavior. And we also focus on cross-border digital crime cooperation as articulated in the UN ODC practical guide for requesting electronic evidence across borders. Another work that we do is through our cybercrime working group of ministers of justice and prosecutors of the Americas called REMHA in Spanish. And through that group, we actually offer capacity development workshops to help member states develop legal tools to enhance their investigations and prosecution of cybercrime capacity. Marissa, if you'd allow me, one of the other items I'd like to highlight to the participants is the work that is done by the Department of International Law of the Legal Affairs Secretariat. And our special rapporteur had done a report based on a survey they issued in 2019, and he finalized it in 2020, where there was an understanding among our member states that there is an interest in the rule of law and the role that law plays in regulating state behavior in cyberspace. Our member states also recognize that there is an unevenness in our legal capacities across the region. There is evidence that the novelness of cybercrime requires more capacity. And one of the things that our member states recognize is there's a need for international legal capacity building, and that needs to be continued. Even though SICTE does much of it, there's a lot more work to be done. Another thing that this questionnaire highlighted is that member states do recognize that even when afforded new opportunities to do so, there is a reluctance to be completely transparent with what they're doing on international law, and it's something that we want to work on improving. I think I'd like to wrap up my intervention by just highlighting 4 key things to think about when you try to apply international regulations on cybersecurity and the role of regional bodies. One is organizations, governments, and diplomats need to recognize that the more we exchange experiences, is the better that we can have cybersecurity capacities improved. The OAS does lead a working group under SICTE that is called the Working Group on Confidence Building Measures. And to date, we have 6 measures. This working group will meet next week. And a part of the discussions have always been around UN measures across our stakeholders and how this group can continue to discuss that. Another point I'd like to leave for you to consider is the need for joint training across regions, the necessity to ensure that we can do incident handling and management of cybersecurity incidents at the highest level, using best practices to ensure that the work of our prosecutors and investigators are much, much, much easier because the evidence would have been preserved properly. Also, cross-regional dialogue around what are the missing capacities that we actually do have. There's been many, many trainings done, and yet we still see that there's a gap in how we cooperate internationally around these issues. So I think the last thought for you is that keep in mind that regional organizations, although we're a large political body, we play a key role as an interlocutory for implementing UN mandates and for helping member states actually fulfill their various international obligations. So with that said, Maritza, I'll hand the floor back over to you. And at least any time that I have left can go to Vanessa. Thank you.
Thank you very much, Carrie, for this presentation that you have shared about some reflections and perspective from the OAS. Very interesting about the examples of the international landscape and the articulate tools that you have can us. Also, the need for the legal capacity international for the member states. Thank you very much, Carrie. Vamos a continuar con nuestra presentación.
We're going to continue with the presentation. There follows a presentation made by Vanessa Fusco, who's a cybersecurity prosecutor from Brazil, who's going to be addressing cybersecurity of the judicial system, the prosecutor's office, challenges and progress made. Vanessa, the floor is all yours. Thank you. Thank you very much. First and foremost, I would like to greet everybody, as much as Carrie, my dear panelists, Marcos. It's a great pleasure being here. Special greetings to Olga and Adrian. It's an honor and privilege to be here once again in the South School of Internet Governance. Very briefly, I will address my talk, let me allow to screen my presentation. Can you see it? Can you hear me? Yes, we can hear you. Great, Vanessa. First and foremost, I would like to discuss what the perspective of the prosecutor office is regarding cybercrime. Over the last 8 years, I've been working on cybercrime, but at this moment in time, I'm working with I'm the prosecutor responsible for doing management work on cybersecurity at the national level in the prosecutor's office. That is, we don't have any regulations in place. That's why I would like to discuss how the judicial power or the public sector in Brazil, since the COVID-19 pandemic, is being under cyber attacks, or how we address cyber attacks. I'm going to talk about cybercrime, the challenges that we have ahead of us in the Brazilian public sector. I'm going to discuss the regulatory framework, national policies, the judicial power. Vanessa, you are going to share the PowerPoint, right? But I'm not seeing it. Could you please share it? I can provide support there. Yes, perfect. Thank you very much. Great. And thank you for telling me. I'm going to talk about the Brazilian Public Ministry and cybersecurity and the building of the national strategy that I'm responsible for. As Marcos well said, there is convergence between cybercrime and cybersecurity. When we speak about cybersecurity, cybersecurity refers to the actions and techniques used to protect systems, networks, and systems and equipment from any kind of invasion or breaches. This guarantees that confidential private data are not violated or infringed with cybercrime. This is what we understand by cybersecurity. However, adopting teleworking or home office increase the rate of these crimes in devices, and in turn, this has led to an increase in cyber attacks. Given this context, Samsung showed a survey on the security and the privacy of corporate environments. And this Korean company shows what the concerns are, given that that corporations may fall prey of these cyber attacks. However, in the public sector, became more vulnerable during the pandemic. And the risk differs from one country to another. However, the public sector as a whole has become more mature at the digital level, has evolved. However, many public organizations are overwhelmed and they don't have enough resources when it comes to cybersecurity. And cyber attackers know this full well. So the judiciary and the prosecutor's office having or holding hearings, hearing cases over the internet. So we are the target for hackers. Are we ready to take on this new challenge? Let me briefly address this topic that is so broad and the cyber attacks of double extortion that have increased significantly during the pandemic in Latin America. Here, Apure, which is a private company, reveals a survey and it helps with resilience. For example, in Latin America, at least 130 companies have fallen prey of cyber attacks. These attacks were conducted by 23 groups of ransomware. We call them double extortion because the device or the website is attacked, although it's encrypted, and then they ask for a ransom. So, to keep this information private, that's why they ask for a ransom. And that's why we call it double extortion. Out of the 20 countries in Latin America, 11 were the target of this sort of attacks. Brazil was greatly affected, followed by Mexico, and then other countries in Latin America. Prometeo was the most active group in Latin America. In matters of intel, we noticed that it was the most active in Brazil. This is the number of victims in our country. And please remember that I'm talking about the private sector here. So all these groups have operations. All these hackers are operating in Latin America. However, let me talk about the great challenge that we had ahead of us that started in 2020. The Ministry of Health and the Ministry of Justice were hacked and our information was compromised. The higher court of justice was not operable because of hacking. And then in 2020, in November, Federal Court, Regional Court number 1, also was attacked, cyber attacked, that affected many citizens. So what Brazil has done in order to overcome these challenges are the following. For example, in 2018, we approved the information security strategy or policy. I'm sure that Gary can tell us from the point of view of the OAS the same information. For example, we have a framework with the information national strategy, with the national plan for information based on the regulations of the federal government. However, we still know that the judiciary or that the prosecutor's office are not part of the executive branch. This is the network that we have in Brazil that has been implemented by the federal law. That is the Federal Network of Cyber Incidents. There's an emergency response system, and I would like to clarify that only the federal government is the one that is required to report these incidents. And in 2020, the cyber attacks in 2020 led to 2021 to implement Resolution 396 that constituted the cybernetic security strategy or information strategy. The first aspect, or the first highlight that I would like to underscore is that cybersecurity for us. Cybersecurity is not involved with hacking, but we have to be involved with information management, and prevention. And this is what we've been doing. We've been doing with the judiciary that created this instrument or this law or this regulation that does not relate to the agents of ICTs. And then, for example, these offices become responsible for cybersecurity. So, in my concluding remarks, I would like to tell you that we need to work and propose a set of measures. So when a cyber attack comes, that the bad guys or the hackers, when the hackers breach all the barriers or firewalls or people restricted access, etc., by using a security culture not only restricted to ICTs, but broader. That is why we became prosecutors of lawsuits in Estonia, for example, to get to know how to work or to understand this whole new universe of cyber attacks. Because not long ago, like 2 or 3 years ago, the prosecutor's office, we were not adept, we were not really aware of what was going on. So I started driving the National Council of the Public Ministry to have a national strategy in place for the prosecutor's office based on the ISO standards 27001 and 002. This means that there should be physical control of the premises, controlling access, fires, access, quality of premises, security perimeters, movements of assets, the management of the premises. For example, we migrated a data center pretty soon, and we wonder if we could place a data center next to a landfill, for example. Not because this could cause a fire and would be creating more damage. That is not going to be an IT error, but something even worse, that could be worse. So we're working along these lines. That is not only that we should work with the logical control in teams, but also with the logical control and the physical control of information in order to ensure cybersecurity. To conclude, just one example. For example, detection measure like smoke detectors is an indication that there could be fire. It's another way of whether we maintain the security of our critical infrastructure. And here we have the extension of fires. In data centers, for example, we don't use water, but we use extinction gases. So there are many things that we can do in our administration, and we are implementing this in the prosecutor's office. The starting point for the regulations that we have or that we're building within the scope of the public ministry. First, the decision and the implication on the high management to elaborate cybersecurity or the public ministry cybersecurity strategies. Also, we formalize the Prime Minister Cooperation Network in cybersecurity, training on information security as well. We need to plan the cost, considering restriction limitations, public service contracts by adopting sustainable measures oriented to individuals or people. As you can see, those statistics coming from the public sector, for example, if hackers steal information from credit card owners, they could sell it in the dark web at $20 per registration. However, if the same groups attacked NHS in the United Kingdom, that is a public entity, and robbed medical histories of this identity, this could lead to more than $480 per registry or medical record. So the public sector needs to carefully consider these risks and be more proactive or flexible to protect their assets in the future. I would like to acknowledge for your presence, all attendees, and I would like to thank you for your patience. Thank you very much, Vanessa, for your interesting presentation on the thefts, the extortions, the new rules, and all the strategies that Brazil has been implementing in order to see this problem in detail. Are there any questions by the people in the room that you have there for our panelists? The virtual people are saying, or the people that are online complain that we're not reading out their questions. So we're going to read a question from Álvaro Saavedra from Bolivia. They said, for Dr. Sal, from the cross-border dilemma that we have, what is the impact with the regulation of the backdoors to providers of content over the web? Are there any people in the room that, because we have many other questions, we're going to take 3 questions or read 3 questions and then we gladly take them. I think that we have 10 minutes left. Microphone. Hey. Good afternoon. My name is Carolina Valenzuela and I come from Chile. Given the excellent talks that were addressed here, I have a doubt in connection with the way we can coexist with public information, especially information coming from the state, because we have public information agencies in many cases. For example, in the case of Chile, we have databases that are of free access or requested by individuals, and this has led to increase cybercrime exponentially. For example, last week we had a very important incident when they infringed or they hacked the judiciary, and for 3 days we had no courts because of a major cybercrime that attacked the courts, infringing I don't know what, but I think there was no way that we could schedule hearings, and the courts could not even explain what was going on. And that is why I have this doubt. How do you coexist information access with these vulnerabilities that we are observing throughout time? One more question. Any other questions? There's a question at the back. Very interesting. It's a question for Marcus. If we consider information as a legal asset that we should protect it from the legally point of view because of economic value or because of its significance, the significance of identities for people, and not merely by protecting because of technology in a traditional way, like privacy or property protection. Now, if we consider it in this way, my question is if it's feasible, because the criminal theory dates back to many years ago, but do you think it's possible or valuable to have new framework or legal frameworks to understand these questions of this new paradigm that apply or that cover information as not something that flows, but something that is transcendental for people, that is not only of economic value, but it's because of the entities and because of the human rights that it implies for all individuals. Shall we address the last one? That is the most difficult one. It's a little bit out of scope with the challenges that I posed. I talked about procedure, but you talked about criminal law, which is totally different. So it's two questions in one. One, if you have information is a legal asset that should be protected legally, taking this as an asset that can be construed in according or in line with the rules, because information has been taken as a protected legal asset. Instead of applying traditional laws, they have classified new crimes. Now, out of the conceptual framework, I do require that, we need further analysis, but in criminal discussions, I believe that you should follow the debates by Jose Agustin that wrote in Barcelona a paper on if it's necessary a new doctrine for cybercrime, and Bashori and other universities and the academic world response. And there's a new framework of a new conceptual framework for analysis. If you see, especially those people that are not involved in criminal law, and if you talk about, for example, processing people, accusations, and all of that, yes, this will require new constructions. However, nobody is in line with that sometimes with that. People agree or may not agree. Some people believe that that could be solved with the classification of crimes that we have right now. I mean, this is at stake right now. It's what we are openly discussing. Any comments from the experts? And there was another question There was a question about the backdoor for ISPs. Yes, if there could be an international obligation to protect backdoors or in ISPs so people or justice system could investigate. In my case, no, it's not possible. This was called crypto dispute or controversy. It was debated in Australia and the United States and Europe. They discussed Apple and any other corporations. If we are going to take it cross border, and leaving backdoors in the private sector is too risky because you're affecting cybersecurity in one way. It's very difficult, not only warranties and identity and privacy, but the backdoors could lead to many things. For example, with the Trojans, there was a Republican senator that even proposed that the antivirus would leave backdoors so the state could enter with Trojans in the computers that they had to investigate. Obviously, it was not passed by Congress, but it's a discussion that is being held in many places. And if we had to have backdoors for further criminal investigation, it would be too risky. I think that they want to expand on their observations with the questions. Now, with the issue of backdoors, I know, specifically to ISPs, that they have backdoors. They call them direct accesses. In the case of wiretapping, for example, the authorities have to request access. And direct access means that the authorities may have access directly without the ISPs not knowing or without being the gatekeepers, because that could be wiretapping that is illegal, and that happens without the knowledge of these people, like Colombia and Paraguay. The governments that allow these ISPs that operate in the spectrum, they said, okay, you want to operate here? Okay, you need to leave a back door, because if you don't do it, there's a sanction, or basically there's no operation, or you cannot operate here. And we know full well you have this in the GNI and the impact of backdoors in privacy of individuals. Sounds extortive. There was a question from Chile as well. Carrie Ann or Vanessa, would you like to say something about it? Yes. I would like to say that in Brazil, we have a law of access to information that classifies what we can or what we cannot do, or we cannot disclose the information on any individual or any citizen. So we have to classify documents, this information, and according to the level of hierarchy of tiers, we can disclose data or not disclose it. So this is a first condition. I don't know if there's a law that provides which is the information that can or cannot be disclosed. Now, regarding cybercrime in the judiciary system, in my experience, what I have learned is that as the prosecutor's office, as the judiciary, we don't have our own structure, our own system, or the commitment of the administration to make large investments or to pay attention to these circumstances that can guarantee the operation of the tribunal. especially if that discontinues the procedures or that is detrimental for citizens. So I believe that we need to bring to the table, probably Carrie can help with this because I had the honor to work with her in 2015 at the OAS. So probably priority should be placed upon this because it is important to say that we do not belong to the federal government of countries. The prosecutor's office or the judiciary is totally independent. So the strategy that revolves around the governments or the administrations should not be directly targeted or involve the judiciary power. And this may help other countries in Latin America to fight or to pursue the same strategy along these lines in the spheres of the judiciary and the prosecutor's office across Latin America.
Muchísimas gracias.
Thank you very much. Thank you very much. I would like to acknowledge and thank all the panelists of today. Dr. Marcos Sai from the University of Buenos Aires, the panelists from the OAS, Carrie, and the panelists from Brazil. And I am Marisa Huerta from Lima, Peru. My greetings to all of you. Thank you very much for participating. I would like to thank Olga and all organizers. I wish you the best. I wish you success as every single edition. And I would like to commend the students for experiencing this excellent workshop. Thank you very much, Marisa, Carrie-Anne, Marisa, and Marcus. Thank you very much for participating in this conference. Thanks very much. We're going to break for coffee for 15 to 20 minutes. Thank you very much.